Okay, good morning, everyone. This is Judge Brian Huber. We're on the record in Douglas County Superior Court on this 18th day of August 2021. We're here in regards to two consolidated cases. That's Quinn versus State, 21-2-0007509, and its companion case, which has been consolidated into the Quinn cause number. That companion case, for what it's worth, is 21-2-00087-09, and that would be Clayton versus State. We have a number of folks on the Zoom today. In preparing for the hearing, I did ask my court administrator to email around and ascertain the identity of the lawyers who will be talking today. I'm going to walk through the names, each of whom appear to be on Zoom today. If I've missed someone who is hoping to speak, I would ask that they let me know if I don't say their name right now. I've got Mr. Purcell and Mr. Zaleski for the state, Mr. Wong for the education parties, Ms. Castillo for one set of plaintiffs, Mr. McKenna for the other, Ms. Foreman for the Farm Association group. Is there anyone else who will be seeking to speak today? If so, please unmute and let me know. And hearing nothing, then I will, let's see, between Mr. Purcell, let's see, the moving parties should go first. They will get a chance to rebut. I would hear from Mr. Purcell or Mr. Zaleski. I'm not sure if you folks have divided up the arguing duties today. Okay, I'll let whichever of you folks want to go first between Mr. Purcell and Mr. Zaleski.
Morning, Your Honor. Thank you. I'm Washington Solicitor General Noah Purcell on behalf of the state. I will be addressing why the plaintiffs lack standing to bring this case under the Uniform Declaratory Judgment Act. And my co-counsel, Chuck Zaleski, will be addressing why the plaintiffs' claims are procedurally improper under RCW 8232. There are 4 points that I would like to cover briefly, Your Honor, in addition to answering any questions you may have. The first is what is and is not at issue in today's hearing. Second is why the plaintiffs lack standing. Third, why the court should deny plaintiffs' request for an exemption from normal standing rules. And finally, why the court should deny plaintiffs' request to amend their complaint. Now, first, it's important to be clear about what is and is not at issue in today's hearing. The plaintiffs are asking this court ultimately to rule on some very controversial political questions and very novel constitutional claims. But none of that is before the court today. Before they can litigate those issues, they have the burden of proving that they have standing under the Uniform Declaratory Judgment Act. That is what today's hearing is about, and that is a burden that they have failed to meet, as we explained in our motion to dismiss, and as I will discuss more in just a moment. Now, the plaintiffs have responded that the state is trying to evade review of the constitutionality of this tax, but that's just not true. We look forward to litigating the constitutionality of this tax, and we have every confidence that it will be upheld. But that litigation can only happen in a case that is properly brought by plaintiffs who will actually owe this tax, and this is not such a case. Now, that brings me to the second issue, why plaintiffs lack standing to bring this case. And the reason really is quite simple. It's that they cannot yet know whether they will actually owe this tax. The tax does not begin to apply to sales of capital assets until 2022. And even then, it contains generous deductions and exemptions. So for example, it completely exempts the sale of real estate, such as homes and farmland. It exempts the sale of assets from retirement accounts. It exempts the sale of qualified small businesses, and it exempts the first $250,000 of capital gains from the sale of other assets. So because of those generous exemptions and deductions, less than 0.1% of Washington residents will owe this tax in any given year. And there is no way for plaintiffs to know now whether they will be among that small group. Now, they cannot know now whether they will be among that small group because no one on the planet, including the plaintiffs, can know right now what capital gains or losses they will have in future years. That is not a factual dispute. That is not a matter of insufficient allegations. That is just a basic economic reality that no amount of pleading can change. So while plaintiffs have clearly demonstrated that they oppose the capital gains tax, they have not demonstrated that it will actually apply to them. So under binding case law from our state Supreme Court, they lack standing to bring this case. Their claim is just too speculative and is too contingent on future events. Now, in arguing to the contrary, the plaintiffs say that they own assets that would be subject to the tax if they sold them in the future and if they incurred capital gains exceeding $250,000. But because of the tax's generous exemptions and deductions, even a person who routinely has large capital gains may not owe this tax in any given year. So, for example, if a person sold a large amount of farmland and incurred a capital gain of $1 million, that would be entirely exempt under this tax. If a person had $2 million in a retirement account and decided for some reason to sell the entire thing, that would be entirely exempt under this tax. If a person, was fortunate enough to buy Microsoft stock 15 years ago and sold it in 2022 at a capital gain of $200,000, they still would not owe the tax because that falls under the $250,000 threshold. So even if it's true that plaintiffs are very wealthy and own significant capital assets, they cannot be sure that they will ever owe this tax. Now, the plaintiffs also claim that the tax is creating uncertainty and causing them to face difficult decisions like whether to move out of state or to sell assets this year. But that argument just confirms how speculative their claim is. If they choose to sell assets now or to move out of state, they may never owe the tax, just providing yet another reason why their claim is uncertain. Their uncertainty about whether the tax will affect them is a reason to deny standing, not to grant it. So the bottom line, Your Honor, is that none of the individual plaintiffs can show standing because they cannot show harm. And because no individual can show standing, the organizational plaintiff cannot either. And that brings me to the third point, which is that this case does not fall under the exemption from normal standing rules that our Supreme Court has sometimes applied. The Supreme Court has applied that exception to normal standing rules only when at least two conditions are met. First, the claim has to be right, meaning that someone has to be able to show that they've already been harmed by the law, which the plaintiffs have not. And second, the Supreme Court has only applied that exception when the merits of the issue have been fully briefed and argued, which has not occurred here. So the court should deny plaintiff's request for an exemption from the normal standing rules. And the final point I want to address, Your Honor, before turning it over to my co-counsel or answering any questions you have, is just why the court should deny leave to amend. And that is just because doing so would be futile. Plaintiffs cannot know currently what capital gains or losses they will have in any future year, and no amount of changes to their pleadings will fix that problem. So it would be futile to amend their complaint, and the court should deny that request and simply dismiss the case. So for all of those reasons, the court should conclude that plaintiffs lack standing to bring this case currently under the Uniform Declaratory Judgment Act and should dismiss the case. I'm happy to answer any questions Your Honor has. Otherwise, I'll turn it over to my co-counsel.
Actually, I do have a question or two, Mr. Purcell. So I took great interest in reading the Kunath versus City of Seattle appellate opinion. And I looked a little deeper into that case, and it looked like that case was brought under the same declaratory judgment statute. And it wasn't jumping out at me when I read it, and I'm hoping you can answer this, whether in that, and maybe one of the other lawyers can help me out if Mr. Purcell can't, but apparently that case was allowed to go forward under the declaratory judgment statute. And it didn't jump out at me whether that new tax in the City of Seattle was being litigated at a time before it went into effect, before any of the plaintiffs had paid that tax in the City of Seattle. I thought it was going forward before anyone had paid a tax or before any assessments had been made and so forth. So are you able to answer that, Mr. Purcell? I realize it's the Kunath case.
Yes, yeah. Yes. The state was not involved in that case, but I'll do my best to answer your question. My understanding is that, yes, that litigation occurred before the tax took effect, but no one made any argument about whether the plaintiffs would owe the tax. It was undisputed that the plaintiffs would owe the tax, and there was no question that the plaintiffs had standing under the Uniform Declaratory Judgment Act. So the motion we're making here, the issues just weren't litigated in that case. No one made that argument. And here, unlike in that case, the law contains such generous exemptions and deductions, and Combined with that, you have the uncertainty about what capital gains or losses a person will have in future years, such that plaintiffs cannot show standing under the Uniform Declaratory Judgment Act. So CUNAP just doesn't speak to this question at all, Your Honor, because it wasn't litigated in that case.
Another standing related question I had was, I'm aware that this motion is being brought by the state under CR 12 rather than CR 56. So CR 56 requires that an opposing party submit actual evidence. Rule 12, on the other hand, in a Rule 12 motion, the court must presume all facts alleged in the plaintiff's complaint are true and may consider hypothetical facts supporting the plaintiff's claims. I note I don't see declarations having been filed. It's a Rule 12 motion. I'm assuming that what the opposing parties, the parties opposing dismissal, are going to say is, hey, look, Judge, you need to presume everything we say in our complaint is true. You can consider hypothetical facts. Hypothetically, we're going to pay that tax, and we therefore have standing. That would be part of the argument. What's wrong with that argument?
Well, Your Honor, the problem with that argument is that it's the plaintiff's burden under the Uniform Declaratory Judgment Act to show standing. And the Supreme Court, our state Supreme Court, has been very clear that standing cannot be based on speculative or hypothetical claims. So you have to read that 12B standard together with the clear standard from the state Supreme Court about what's necessary to show standing. And plaintiffs have not alleged and cannot allege that they know they will pay this tax because they just cannot possibly know that at this point. That is inherently speculative, and no amount of pleading can change that. And to be clear, Your Honor, it's not as though we're asking them to wait, 10 years to litigate the constitutionality of this tax. If a plaintiff really wants to, they could sell a capital asset early in 2022, incur capital gains, pay the tax early, and file a lawsuit. Certainly, that would be sufficient to create standing under the Uniform Declaratory Judgment Act. But what's not sufficient is just to say that we own capital assets that would be subject to the tax if we sold them and if we incurred gains of beyond $250,000.
Okay, thank you very much, Mr. Purcell. Mr. Zaleski.
Good morning, Your Honor. Chuck Zaleski, Assistant Attorney General, representing the Department of Revenue. So as Mr. Purcell indicated, there is an additional independent reason why these cases should be dismissed. Namely, the Washington Legislature has established a mandatory process for challenging an excise tax in Superior Court. And that process is set out in RCW 8232. And in particular, it's sections 150 and 180 of that title that set out sort of these procedural requirements. Under those sections, a person seeking to challenge a tax in Superior Court must either pay the tax and sue for a refund, or there's a limited exception where you can challenge an assessment of a tax on constitutional grounds. And that's the second sentence of 8232-150. Here, none of the plaintiffs have paid the tax, and none of the plaintiffs have been assessed for the tax. So as a result, they have not correctly invoked the jurisdiction of the Superior Court in this case. Now, as a starting point, there's two important legal principles, established legal principles that are I think, an important guide in analyzing this issue. The first one is that it is black letter law that the legislature has the power to enact procedures directing the manner in which an action can be brought in Superior Court. And there are a slew of cases that address that concept, but the most recent one from our state Supreme Court was earlier this year in the Freedom Foundation versus Teamsters Local 117 case. And in that case, the court was very clear and emphasized that courts will require substantial compliance with statutory methods that are provided by the legislature. The state is not aware of any authority to the contrary. So, this is an established principle in Washington. The legislature does have the power to set out the procedures for invoking the jurisdiction of the Superior Court. A related principle of law in Washington is that declaratory relief is generally not available when the legislature has provided a satisfactory method for determining a particular type of case. And case law on this principle goes back at least to the 1940s. From my research, I found cases going back to the 1940s. But two more recent cases, and the court may be aware of these, that sort of show the flip side of this issue, both sides of this issue. The first is New Singular Wireless versus City of Clyde Hill, which both parties have cited that case in their briefing. And the second one is a case called Grandmaster Shin Yin Liu versus King County. And that's a 2002 Court of Appeals Division I case. And again, they show the flip side of this equation. So in New Singular Wireless, the Supreme Court very carefully analyzed whether or not there was a satisfactory method established by the legislature for bringing an action challenging a municipal fine. And after determining that there was not, the court said, okay, declaratory judgment, or the Uniform Declaratory Judgment Act, is an appropriate means to bring this action in front of the courts. The flip side of that is the Grandmaster Shin Yin Liu case, which involved a land use issue where the petitioner did not comply with the requirements of the Land Use Procedures Act, LUPA. So in that case, the Court of Appeals very carefully analyzed whether or not LUPA was a satisfactory method, found that it was, and then held that the petitioner in that case could not use the Uniform Declaratory Judgment Act as a means to end run the statutory procedures that the legislature has enacted. Now here, the legislature has enacted a comprehensive system for challenging a state excise tax in Superior Court. And not only is it satisfactory, it's mandatory. The language in 8232-150 first sentence makes it clear that this is a mandatory method for bringing an action in Superior Court challenging an excise tax. And that system requires prepayment of the tax unless you fall within that limited exception where you can challenge an assessment on constitutional grounds. Now, the plaintiffs here admit that they have not been assessed the tax, so that exception does not apply. They fall within that general provision, the first sentence of 8232-150, they have to pay the tax and file an action for refund. If as Mr. Purcell noted, that if any, and not just these plaintiffs, but if anybody in general wanted to expedite judicial review of the capital gains tax, they could do so next year simply by making a qualifying sale of a capital asset that exceeds the $250,000 threshold, pay the tax due on that transaction, file an action in Thurston County Superior Court under 8232-180 seeking a refund. That gets that would resolve or comply with the statutory methodology that our legislature has established. But until then, there's no legal or equitable reason for the court to permit these plaintiffs to bypass the statutory mandatory process set out by our legislature in 8232-150 and 180. I just want to make one other quick point, because you had mentioned the Kunith case involving the City of Seattle tax. With respect to my issue that I'm dealing with, 8232-150 and 180 apply to state excise taxes. So there would not be a similar, or at least I'm not aware of any similar limitation on challenging a city tax in Superior Court. I'm happy to answer any other questions the court might have, but just to quickly conclude, the legislature has established the statutory method for challenging the capital gains tax in Superior Court. These plaintiffs have not substantially complied with that statutory method. As a result, their complaint fails as a matter of established law and should be dismissed. And again, I'm more than happy to answer any questions that the court might have.
I do have at least one question anyway. I realize I'm going to talk about Kunath versus City of Seattle again. I realize it was a city tax, not a state tax. That's different. But it's interesting in that, number one, it was a 2019 opinion, and it's always helpful to look at more recent decisions and how they summarize the law. Under the analysis section in Kunath, it sets out some background, and it lists some precedential case law going back to the Culleton versus Chase case from 1933, and a number of cases since then that lay out some of the basic principles in cases like this. And I mean, when I say cases like this, I mean cases in which the constitutionality, the facial constitutionality of a tax law is challenged. And I'm seeing that Culleton versus Chase was, that opinion was issued, I believe, in 1933. I've got RCW 82.32.150 pulled up, and at least based on my very limited research, admittedly, it looks like that statute may not have been adopted until 1935. It just makes me wonder whether all of these cases that are discussed in Kunath as sort of landmark decisions in what got us here to the existing set of rules in these kinds of cases, whether each and every one of those cases was brought under, whether first the plaintiffs paid the tax and then afterward filed the suit, and whether all of them were filed under RCW 82.32. I haven't pulled all of those cases, and I'm wondering if you have any input on that question, because it seems like if there's a 1933 case, it appears to me, at least preliminarily, that it precedes the adoption of the statute. Were there statutory changes? What do you make of this idea, this question that I've raised about whether all of those cases were involved plaintiffs who had already paid the tax and then brought the suit under 8232?
So it's a difficult question to answer. The Cullen v. Chase one is the easier one to answer because that one did involve a tax, a general income tax that was passed prior to 1935, when our excise tax code was established in 1935. The excise tax code included 8232.150. So Cullen v. Chase was prior to that. Some of the other cases were after 1935, the Jensen case and some others. I'm familiar with those cases on sort of the substantive legal issues being addressed in those cases, but I have to admit, I have not studied them to determine sort of the procedural posture that resulted in the case coming before the courts in those cases. I don't believe any of those cases directly address whether it's proper to challenge an excise tax in Superior Court prior to paying the tax. Either that's not addressed in those cases, or the tax had been paid and there would have been a proper refund lawsuit, probably filed in Thurston County. But I would have to go back and reread those cases to sort of try to put my head on, or try to wrap my head around what was the procedural posture that led to the lawsuit.
And I realize, Mr. Zaleski, it's probably unfair for me to ask that kind of deep in the weeds kind of question and hit you cold with it. I could have at least warned you with giving you some kind of warning. But in any event, these are the kinds of questions that I have. I'm assuming, if the state's argument is correct, that either all of those cases would have been brought, as the state is arguing, they must be brought in a post-tax payment scenario, having been brought under RCW 8232, or there would be a good reason why they didn't. For example, the first case maybe preceded the statutory scheme. Was there anything else you wanted to add, Mr. Zaleski, before I move on?
No, I think that covered everything I had to say.
Okay, thank you very much. Mr. Wong, I know you represent the education parties, and your client or clients are asking that the dismissal be granted. Was there anything you wanted to add?
No, Your Honor, we don't have anything in addition to what the state has already said, and we just join in their request. I will put in for whatever it's worth. My recollection of the Kunaf case and all of that prior case law also was the same as the state's, that just the issue and the question of standing did not arise, and so it wasn't addressed. Whether or not the case could have been dealt with that in those ways, is a separate question, but I don't recall it being a substantive issue before the court.
Thank you. Thank you. Okay, then the opposing parties are represented by Ms. Castillo and Mr. McKenna, as I understand it. Have you folks worked out which of you would like to go first?
We have, Your Honor. I'll speak first, addressing justiciability and standing, and then Ms. Castillo will address the statutory issues.
Thank you.
Your Honor, to begin with, I want to point out that this is not about a controversial political issue. This case was brought as a constitutional challenge to the facial validity of the new capital gains tax. Facial constitutional challenges to a new law are appropriate for the court to resolve now, including to this tax. This case is justiciable. First, because plaintiffs are entitled to the benefit of all reasonable inferences and to hypothetical facts consistent with the facts they allege. And the facts are, Your Honor, that plaintiffs own capital assets, as we alleged in the complaint, that when sold or transferred will generate gains that are subject to the new tax. While the consistent hypothetical facts to which we're entitled include the fact that they will sell or transfer assets which generate capital gains that are subject to the new 7% tax. Thus, defendants may obtain dismissal under 12b-6 only if this court concludes beyond a reasonable doubt that the plaintiffs will not be able to prove any set of facts which would justify the relief they seek, which is a declaratory judgment that the new capital gains tax is illegal and unconstitutional. The court must presume all facts alleged in the plaintiff's complaints are true and may consider hypothetical facts supporting the plaintiff's claims. You can look at Kinney v. Cook, Aleem v. City of Seattle, which is a recent Court of Appeals decision involving a new Seattle ordinance. There are many examples. Second, this case is justiciable because the mature seeds of a dispute were fully planted when Governor Inslee signed the bill into law creating this tax, a law that took effect over 3 weeks ago on July 25th. On the other hand, Your Honor, at the pleading stage, the state is not entitled to its own hypothetical facts, such as an assumption that plaintiffs cannot know if they, or in the case of the Farm Bureau, any of its 46,000 members are going to pay this new tax. What's happening here, Your Honor, is that the state is simply trying to insulate itself from judicial review, as much as the state would claim that's not true. But we've seen them do this before. They unsuccessfully attempted to do this recently in the Washington Bankers Association case, which we cite in our brief, a case that I litigated. I also litigated the Kunaf case, and I'll speak to that as well. In that case, they brought a motion to dismiss on similar grounds to today, and they were turned down. Their motion to dismiss was denied on the grounds that the state is arguing today, and that challenge was allowed to proceed. In Kunaf, it's true that the city did not challenge the standing of the Kunaf plaintiffs to challenge the new tax, but as you pointed out in the Court of Appeals, they cite case law and they assume that, in fact, the case could go forward. So there's no question there was no question in that case that the taxpayers in Seattle were allowed to challenge the tax before it was attempted to be collected, before it was assessed on them, before they had to pay it. The state's June 2021 budget forecast for this new capital gains tax is that it will raise $500 million a year from thousands of individuals. While the state claims it's just a small group of taxpayers who will pay it, it's about 7,000 a year, generating $500 million a year. If this isn't a substantial question of public importance, I don't know what is, but there's no speculation here. This tax is going to be collected. It is a dead cinch certainty to be collected from many thousands of people per year. Nevertheless, the state argues that imposition of the tax is too speculative for judicial review and that a facial challenge to its constitutionality can't be heard before the tax has been paid, which just is not true. Now, Your Honor, the plaintiffs have brought their challenge, as you know, under the Uniform Declaratory Judgment Act, UDJA. Washington Superior Courts, even before the UDJA, had original jurisdiction in any case involving, quote, the legality of any tax. That's from our state constitution, Article 4, Section 6. It's also reflected in RCW 2.08.010. In addition, superior courts have broad remedial authority under the UDJA to declare right status in other legal relations. That's RCW 724.010, including whether a statute increasing the amount of an excise tax is constitutional. That's Washington State Coalition for the Homeless. So when enacting the UDJA, the state waived its sovereign immunity to allow the Superior Court to exercise jurisdiction to adjudicate claims for declaratory judgment that a tax statute and other kinds of statute violate the state or federal constitution. Because it is remedial in nature, the UDJA is to be liberally construed and administered. Now, regarding a facial challenge to a tax, consider the case of Lee v. State, a Supreme Court case involving a facial challenge to a voter-approved tax initiative. The Supreme Court held in Lee that the constitutional challenge, which was brought 2 years before that new law affecting taxes took effect, was justiciable because the constitutional claims did not require more time. As the court noted, the act was either constitutional or it was not. Similarly, Your Honor, in Seattle King County Council of Campfire, the Supreme Court held at page 56 that because the dispute took the form of a declaratory judgment action concerning the proper construction and constitutionality of the statute, the court could determine the facial validity of the statute itself. This case then is justiciable under the UDJA. The defendants argue the case isn't right because no plaintiff has been assessed for the capital gains tax, and supposedly they can't know if they'll owe it or not. But to show rightness, Your Honor, plaintiffs need only demonstrate the mature seeds of a dispute, as the Supreme Court has noted in recent cases like Lee v. State and in other cases like Diversified Industries. The capital gains tax statute was passed into law, and its effective date was over 3 weeks ago on July 25th. There is nothing merely dormant, hypothetical, possible, speculative, or moot about this tax. It is an absolute certainty that unless enjoined, the state will enforce the statute, levying hundreds of millions of dollars in taxes on many thousands of Washington residents. Individual plaintiffs allege, and the court must accept at this stage of the proceeding, that they own capital assets that will be subject to the tax. In addition, the association plaintiff, the Farm Bureau, has over 46,000 members, many of whom will be subject to this tax, either because they already own taxable capital assets or are making decisions over the coming months about whether to acquire taxable capital assets. Plaintiffs are entitled to all reasonable inferences and to hypothetical facts consistent with their allegations. Thus, plaintiffs are entitled to hypothetical facts that they will be engaged in active tax planning immediately and that they intend to sell capital assets that will be subject to the unconstitutional tax. Your Honor, standing doesn't just arise because someone has to pay the tax. Paying the tax is not the only injury. We're also alleging injury from the existence of the tax, which we know is in effect now and will be operationalized in January of next year. And it includes impacts on values of assets. It includes plaintiffs having to engage in estate and tax planning in deciding whether to acquire or dispose of taxable assets this year before the tax becomes effective next year, and so forth. In consequence, plaintiffs have sufficiently alleged facts to establish that they will suffer an injury in fact. You don't have to suffer the injury now. You have to show that it's not unreasonably speculative that you will suffer an injury in the future. And when the state says that the claim injury is too contingent, notice they say too contingent. You can have a contingent injury based on an event that is not too unlikely to occur. Here, there isn't anything more common than buying and selling capital assets and paying taxes. There's nothing speculative about this case. The arguments to the contrary that you've heard this morning turn on pure speculation beyond the face of the complaint, that the plaintiffs won't be taxed, that the plaintiffs can take advantage of a deduction, that the stock market will decline, and so forth. The state turns our 12b-6 on its head. Any challenges to standing based on whether a plaintiff will or will not be subject to the capital gains tax are inappropriate at the pleading stage of the case. The state may have a right to take discovery to test these allegations, but determining facts on the record has to await summary judgment if the facts are undisputed or trial. Under 12b-6, the state may not offer its own facts that are not pled to prove that the claims are speculative. The reality here is that the state doesn't adequately grapple with the hypothetical facts of which the plaintiffs may avail themselves. So again, Your Honor, as in Levy State, the question here for the court is whether this statute is unconstitutional on its face or not. Nothing about that is going to change in the next 6 months or 12 months or 2 years. Your Honor, let me pause there. I'm happy to address the public importance doctrine as well if you'd like, but I think it's beyond dispute that this case involves major questions of public importance. As the farm associations pointed out in their amicus brief, they're already being affected by this statute. We know it's in effect as a law. The first tax year is next year. People are already being impacted by it, but I'm happy to speak to the public importance doctrine more fully if you would like, and of course to answer other questions you may have before turning it over to Ms. Castillo.
I appreciate your offer. This court is satisfied that it would be difficult to argue that the statute is not of public importance. So I think we can move on, but thank you for your comments, Mr. McKenna. Ms. Castillo.
Thank you, Your Honor. The state is attempting to avoid the constitutional review of the capital gains statute by invoking a statutory scheme in RCW 8232 that does not govern this lawsuit. As just discussed by my co-counsel, the court has authority under the UDJA, and the plaintiffs have standing to determine whether ESSB 5096 is facially unconstitutional. Before I get to the heart of my argument, I'd like to address this court's question with respect to the cases that were cited in the Kunath decision and have the form of basis for this lawsuit today. And the first case that I'd like to address is Jensen versus Henneford, which was decided 1 year after the tax code, current tax code was put into effect in 1935. It was decided in 1936. And that case was specifically on the basis of the plaintiff's pleadings. And the paragraphs that I'd like this court to refer to are at paragraphs at 185 Washington 214 through 215, in which the court summarizes the allegations that the respondents had asserted in challenging the constitutionality of that income tax statute. And in those cases, each of them were based only on the allegations brought in the complaint that the parties would be subject to the tax. There is no indication that the court had any concerns regarding their standing to bring such a constitutional challenge. And there's no indication based on any of those facts that any of them were anything but subject to the tax. They had not paid the tax first. And then also same with Power Inc. versus Huntley, which was decided in 1951. That case too, there is no indication in the record whether it was anything decided more than on the challenge in the complaint based on the constitutionality of that particular tax. And what's important here is the key to what type of dispute that this is. And this is a challenge to a constitutionality of a statute that the legislature has adopted. It is not a challenge to the administration or collection of taxes imposed on a particular taxpayer. That is governed by RCW 8232, and those statutes, which require certain procedures in order to challenge a tax assessment or to seek a refund, simply are not applicable here. And the Seattle King County Council case of Campfire versus Department of Revenue, which the state does rely on explicitly to make this point, the court expressly found that it could determine the facial validity of the statute at issue in the declaratory judgment action, but it could not determine the Department of Revenue's administration of that statute because other statutes governed that review and had not been invoked. And that this court can see at 105 Washington 2nd 58. The same in Allen versus Public Utility District number 1, in which the Supreme Court also distinguished between actions challenging the authority to levy a specific tax and an action seeking to prevent collection of a particular tax. The court found that the taxpayers were not deprived of the right to challenge the government's authority to oppose the tax in the first place, even though there were other tax remedies. The state tries to distinguish that statute by asserting that it's based on another set of procedures. Well, what it highlights is that the Supreme Court has long determined that there's a difference between a UDJA action challenging the validity of a statute and the specific tax collection statutes that must be invoked to challenge a tax assessment or to seek a refund. And a close review of the actual statutes in RCW 8232, as well as the case law, demonstrate that the state is relying on inadequate authority to avoid review in this case. RCW 8232-150 specifically says in the very first sentence, all taxes, penalties, and interest shall be paid in full before any action may be instituted in any court to contest all or any part of such taxes, penalties, or interest. The state is taking the words any action out of context of that sentence when the plain language says it must be to contest the such taxes, penalties, or interest. And the Court of Appeals in the AOL decision, the Kirkland decision, and the Morrison-Knudsen decision all concluded that those three words, those four words, such tax, penalties, and interest, must mean an assessment. And that makes sense when you can only pay taxes, penalties, and interest after an assessment. The state's reliance on the Booker decision is also misplaced because in that case, the Department of Revenue instructed the taxpayer to pay certain taxes. The taxpayer then challenged the department's administration of those instructions under the Administrative Procedure Act, but not the procedures in RCW 82 for challenging a tax assessment. And even that court recognized that a tax can be prospectively enjoined when the assessment violates the federal or state constitution, and that is found at 158 Washington App 84. 150 just simply does not bar the court's review of the constitutionality of the tax statute at issue here. The plain text of RCW 8232-180 also only applies when there is a person who is seeking to obtain a refund for a tax that is required to be paid. And the Lacey Nursing Center case, which the state also cited in its brief, the state replaced the words actually used by the court. It replaced challenge the imposition of a tax generally with what the court used, which is the right to bring an excise tax refund suit must be exercised in the manner of RCW 8232. But here, all we're speaking about is the constitutionality of a statute that the legislature has adopted and whether that statute satisfies both the state and federal constitution, which plaintiff asserts it does not. Finally, the state's assertion that there is an existence of a future remedy should preclude this action because plaintiffs could file and pay taxes and seek a refund does not preclude the proposed declaratory judgment action here. The new singular wireless case and the Grand Master case, which the state cited today, the new singular wireless case explicitly made the point that the existence of another remedy does not preclude a declaratory judgment action. And it specifically cited two statutory authorities. First, RCW 724010, which is in the UDJA, in which it says that a court of record within their respective jurisdiction shall have the power to declare rights, status, and other legal relations, whether or not relief is or could be claimed elsewhere. The Supreme Court also cited Civil Rule 57, which says that existence of another adequate remedy does not preclude a judgment for declaratory relief in cases where it is appropriate. The Supreme Court in New Singular then went on to overrule a decision known as the Reader decision. And the Reader decision is important because the Court of Appeals decision that the state just cited to this court today in the Grandmaster Shoe case specifically relied on the Reader decision. And so the basis for Grandmaster has been overruled by the Supreme Court and by the adoption of CR 57, in which the state legislature and the courts have held that declaratory judgment actions are available even if there is an alternative remedy. So even if the state is correct that at some point in the plaintiffs could obtain pay the tax and seek a tax refund case, that does not preclude the action here, in which this court is asked to review only the constitutionality of the legislative action and nothing further. If this court has no further questions, then I'd be happy to answer any questions or to address any other points.
Thank you, Ms. Castillo. No questions at this time anyway. Ms. Foreman, I appreciated your brief. Is there anything you'd like to add during today's hearing?
The previous counsel hit all the points I had taken notes on during the opposing presentation, but I will speak to the motion to transfer if it's time to do that, or I can wait until that's before the court.
Yeah. Now would be a fine time. Go ahead.
I would note that the plaintiff's initial choice of forum deserves strong deference by the court unless the balance of justice is strongly in favor of the defendant. That choice of forum should be respected. And with respect to my clients who live far away from Thurston County, where an action is proposed to be transferred, that would discourage a lot of farmers, people who live in rural areas, from challenging the constitutionality of unconstitutional tax laws. And we submit that that would be contrary to the interest of justice. As noted in my brief, the mills of justice grind with equal fineness in every county of the state, including Douglas County, and we would request that the court keep the case here.
It is true that the town of Waterville is the highest elevation of any incorporated city or town in the state of Washington, but I have no illusions that the Douglas County Superior Court is the highest court in the land, so to speak. It is inevitable, don't you think, that this case will end up in Olympia at some point?
It may, but that doesn't mean that it shouldn't be allowed to start anywhere an aggrieved taxpayer questions the constitutionality of the statute.
Okay, thank you very much, Ms. Foreman. I appreciate it. All right, it is the moving party's turn for rebuttal if they wish, and so I'll turn it over to Mr. Purcell or Mr. Zaleski. I don't know if they've worked out who would like to talk about rebuttal, but if the state does wish to address the motion to transfer venue, I'm hoping that you'll include something in that area if you choose to make rebuttal arguments. So, Mr. Purcell or Mr. Zaleski?
Your Honor, I'll go first, and then Mr. Zaleski will add anything on the 8232 issue. First, I just want to emphasize that the state is absolutely not trying to evade review in this case. There's no question that this statute will be in court soon, and the constitutionality of this tax will be litigated fully. What the state is trying to do is to enforce the basic procedural rules that our Supreme Court has set out for ensuring that cases are properly brought. And the court has emphasized that those rules matter because making sure that plaintiffs who bring a case are actually affected by a case, by a law that they're challenging, is an important part of making sure that the actual implications of the law are in front of the court and not just hypothetical speculation. So, I mean, in this case, for example, the plaintiffs are alleging that the sky will fall essentially from implementation of this tax, when in reality, the tax will apply to very few Washington residents and will have a very small impact even on those. So that's part of why the Supreme Court has set out these rules and why the state is seeking to enforce them. We fully expect to litigate the merits of this case soon, and we fully expect to prevail on the merits, and we look forward to doing that. But that is not the issue before the court today. Now, the second point I want to address is this idea about hypothetical facts. Now, the plaintiffs admit that they cannot know right now whether they will owe this tax in a future year, and they have to make that admission because no one can know that at this point. But they say, you have to give us the benefit of the doubt that we might, and we're saying that we might. The problem with that argument is that literally any person in the state of Washington could make that allegation. Even a person who currently has 0 assets could say, I might win the lottery in November, and then I'll have millions of dollars, and then I'll sell assets in 2022. I might have a relative I don't even know about who I will inherit millions of dollars from, and then I will, sell assets in 2022. 100% of people in Washington could make the allegation that they're making, and 99.9% of them will not owe the tax. So if anything is speculative, Your Honor, that is speculative. Now, I admit that there's not a lot of Supreme Court case law on exactly what that hypothetical fact standard means in the motion to dismiss context of a standing argument. But it is very clear that it's the plaintiff's burden to show standing under the Uniform Declaratory Judgment Act. And as I just said, if 99.9% of people not being affected is not sufficient to show, if that's not speculative, then I just don't know what is. The third point I want to address is that Mr. McKenna mentioned that they're also alleging current harms from the tax. There's 2 real problems with that argument. First of all, many of the harms, let me touch on 3. First, some of the harms they're alleging, such as a reduction in the value of assets they hold currently, are only alleged in the amicus brief. They're not alleged anywhere in the plaintiff's complaints. And the case law is very clear that standing can only be based on the plaintiff's allegations, not allegations of others. Second, those allegations, the allegations about having to make decisions about whether to move or whether to sell assets, just highlight how speculative their claim is. And the third point is that even if they're right that they're incurring some costs now because of the tax, there is nothing this court can do to redress that injury if it's really happening. Their claim is that they need to know before the end of this year whether the tax is constitutional so that they can decide whether to move or sell assets or do other things by the end of this year. But they haven't filed a motion to expedite this case in any way. They haven't sought preliminary relief. Even if they filed a motion tomorrow asking this court to rule on the merits, the court can certainly do that by the end of the year. But as Your Honor recognized, that ruling, any ruling, would inevitably be appealed to the state Supreme Court, where review would be de novo, where the statute would be presumed constitutional unless proven otherwise beyond a reasonable doubt. And there's certainly no way that the state Supreme Court would rule on the merits before the end of this year. So the idea that somehow this court could give them certainty such that they could make decisions knowing with certainty before the end of this year whether the tax will apply to them or not it's not plausible. And so the harm that they're alleging sort of secondhand is not redressable. And so that's a separate reason why there's no standing to bring those harms before the court or under that theory. On the venue point, Your Honor, I don't want to say much beyond what's in our briefing. It's just that the tax was enacted in Thurston County. It will be administered from Thurston County. It will be administered in a uniform way across the state. The Thurston County Court deals with tax cases routinely under RCW 8232, 150, and 180. And so that's why we've made that request. And finally, Your Honor, the state is not disputing that the issues in this case are important. But that is not the test for the exception from the standing rules to apply. The Supreme Court has been very clear that just because an issue is important does not mean standing rules go out the window. You still have to have a right claim that's crystal clear from the cases cited in our briefing, meaning that someone has to have actually been harmed already. And you still have to have the merits issues briefed and argued, which has not happened here. So, we agree that the case is important. That does not mean that standing rules go out the window. Those other requirements have to be met. So for all those reasons, Your Honor, we would ask you to hold that the plaintiffs have not met their burden under the Uniform Declaratory Judgment Act to show standing and that you dismiss the case. I'm happy to answer any further questions you have. Otherwise, I'll turn it over again to my co-counsel.
Thank you, sir. No questions at this time. Mr. Zaleski?
Yeah, Your Honor, thank you. I only have 3 really quick points. The first point is that most of the case law that the other side has relied on today, a lot of that case law simply doesn't apply to excise taxes and does not address the anti-injunction language of 8232-180. For example, the campfire case was a case involving property taxes. So there's a different anti-injunction statute in the property tax code that it's much broader. It allows a lot more different types of cases to be brought than the limited types of cases that can be brought under the excise tax code under 150. The same is true of Allen versus Public Utility District Number 1. That was a property tax case. It had a materially different statutory process, which allowed injunctive relief if there was a claim that the tax was void. You only have to claim that it's void to get beyond the anti-injunction language of the property tax code. Again, Jensen, the case involving the 1936 decision involving the income tax statute, I would have to go back and reread that to determine whether or not that income tax statute incorporated RCW, what is now RCW 8232, or if it had different anti-injunction provisions. But I'm fairly certain that the court did not address what is now 8232-150 in that case. So on a related point, the entire public policy or purpose behind these anti-injunction type statutes is that the legislature does not want tax litigation to disrupt tax collection. And this policy makes sense even when a taxpayer raises a constitutional question. If there were a blanket exception on constitutional questions, then it would be easy for anybody to get around the purpose of the anti-injunction language by simply including a constitutional claim in their petition. And additionally, there would be no principled way for a court to make a decision on whether a constitutional claim is meritorious versus frivolous or incorrect. And so the courts would then have to be making these ad hoc decisions on whether, hey, is this a constitutional claim that deserves to go forward, notwithstanding the anti-injunction language in 8232-150 versus other types that would not. So you would, if that were the law, you would have seen a slew of Washington court decisions addressing the constitutionality of excise tax cases where the taxpayer has not paid the tax, but is alleging a constitutional violation. And those cases just do not exist. Mr. McKenna referenced a Superior Court decision from King County from last year, but that is not authority. That was, the court made a decision based on the facts and arguments in that case. We think it was incorrect. That's one of the issues on appeal in that case, but it's not authority in the sense of a appellate court decision. The appellate court decisions that are telling or significant in this for this purpose are the cases that directly address 8232-150 and 180, and those are Lacey Nursing Center, Booker Auction. The Tyler Pipe case is interesting because Tyler Pipe, that was the 1982 case, that was a case where the exception in 8232-150 applied because there the taxpayer had been assessed for the tax. Those are the cases that directly address the meaning and intent and purpose of 8232-150 and 180. And sort of a backup argument on the policy behind anti-injunction, an additional policy reason, not the primary one, but an additional one is that when you have tax litigation, the state is good for the money. The state will pay a refund if the challenging party is successful. But it's not as certain whether a taxpayer that loses a constitutional challenge on an excise tax would then turn around and pay the tax after exhausting their appeal. One final point, this goes to the venue. Mr. Purcell articulated sort of the basis for our venue argument, but I would also point out one additional fact, and that is Section 14 of the statute, the act that created the capital gains tax. Section 14 expressly states that RCW 8232 applies to the capital gains tax. So implicitly in that, the legislature was directing that any challenge would be through the mechanisms of 150 and 180, which are in Thurston County. And so I think that's an additional point that's worth making on venue. Again, I'm happy to answer any other questions the court has.
I want to make sure I understood. I didn't see anything about that in the, I mean, it's possible I missed it, but I didn't see anything about that last point you made in the briefing. You're saying that section 14 of the new statute says that RCW 82.32 applies and is the exclusive remedy.
It doesn't say the exclusive remedy, it says the provisions of 8232 apply to this act, to this tax. So that incorporates all of 8232, including 150 and 180. And so the argument is implicitly the legislature understood, or what they expected was that a challenge to the tax would be through the mechanisms that the legislature has established in 8232, 150, and 180. And that was not part of our brief, so that is an argument on top of what we had in writing in our briefing.
Well, okay, just to clarify, Your Honor, I do think we pointed out in the brief, in the background section about describing the statute, that section 14 specified that 8232 would apply. It just wasn't a separate venue argument that we made in the brief.
Okay, thank you, Mr. Purcell. All right, Mr. Wong, if you wish to weigh in, I'll give you the last word.
I don't know if I should get the last word in this one, but I appreciate the offer. There's nothing further that I have to offer beyond what the state has already argued. Thank you, Your Honor.
Okay, thank you very much. And thank you for your excellent presentations, counsel. Here's what I'd like to do moving forward. I'm going to take this under advisement. We like to keep things relatively informal around here. We don't do a lot of tax cases in Douglas County, and I'm not the type to foreclose or prohibit parties from hearing some of the discussion, some of the court's questions, and the parties can probably tell the court is really interested in this issue about RCW 82.32 and whether it's exclusive or not. And for example, I asked the question, what about those cases, those older cases going back to 1933 that seem to be landmark cases according to the Kunath court? Did they involve RCW 82.32? And if not, why not? Is it just simply that facial constitutional challenges to tax statutes don't have to be brought under RCW 82.32? These are the kinds of questions that I will not prohibit the parties from submitting supplemental briefing. It's going to take me a little bit to put together my letter ruling. And I'm thinking that if the parties do wish to submit any supplemental briefing on really anything that we talked about today, or maybe things that we didn't, but it has to be obviously pertain to the pending motion brought by the state. But if folks do want to submit any supplemental briefing to follow up on some of the discussion, I wouldn't have any problem reading that. All I would ask, though, is that any supplemental briefing be provided. Today's the 18th, within 1 week from today. And during that week, I'm going to be working on my letter ruling, but we may be able to put a finer point on certain issues if the parties wish to submit supplemental briefing on really any issue. So I thank everyone for your presentations today. Is there anything that anyone would like? I always like to open it up. Is there anything anyone would like to raise today? A question, a procedural point, clarification before we adjourn for today, and look forward to issuance of a letter ruling. All right. Thank you very much, folks. Hearing nothing, we'll just go ahead then and adjourn for today. Take care, everyone. We will go off the record.